Good morning, Mr. Mitchell.
Good morning, Chief Justice Marshall, Associate Justices. May it please the Court. I'm seeking a change to Section 3.3 of Rule 301, and I believe that that change is justified for three different reasons. First of all, I believe that, and respectfully submit, that equal protection analysis compels the change. I believe that public policy considerations justify the change. And I submit to you that satisfaction of the requirement that only qualified applicants be admitted to the bar is strengthened by this change. I'd like to start with equal protection by saying that everyone who gets into the bar in Massachusetts must have an appropriate legal education. That can be from an ABA-approved law school. It can be from a Commonwealth-approved law school, in which case one need not be a member of the bar in order to take a bar exam. Or it can be an attorney from another state or a foreign country. When such an attorney comes from another state, such as me, the attorney need not have graduated from an accredited law school, an unaccredited law school graduation, coupled with admission to the foreign states bar, which means that the attorney has passed the foreign states bar, satisfies the legal education requirement for admission to the bar in Massachusetts on motion.
Right.
On motion.
But, Mr. Mitchell, don't you think, though, that there is some validity to the point that it may satisfy, I forget whether that's 6.1.4, but you need to look at all of them together so that it's also that included in allowing the admission by motion, even in a different kind of law school, would be that the person has practiced for a time that, at least on the website it now says, 5 of the last 7 years.
Well, that's absolutely correct. For admission on motion, there are many qualifications, and I'm not seeking to have that portion of the rule changed. And in fact, I think it's important to point out that if the question is asked, well, isn't it rational, as I believe you are asking, Justice Botsford, isn't it rational to say, well, okay, you know, he didn't go to an accredited law school, but he's a member of that state's bar and he has 5 years' experience. Why shouldn't we just waive the bar examination requirement? Isn't that, and allow that person to come in on motion, isn't that rational? And that is rational. And I'm not making a facial challenge, but this is in the context of an equal protection challenge. We have to compare what that means when we let somebody in that position into the bar on motion with other similarly situated applicants. That
well, would they always be similarly situated because they might or might not have any experience practicing law, correct?
Well, Your Honor, I submit respectfully that the similar situation, if you will, is that they have received a legal education that is sufficient for admission to the bar. If you look at Section 6.1.2 and you look at Section 6.1.4, you can see that these are two distinct sections, two distinct requirements. What the Board attempts to do is to conflate these two into one sort of mush of experience/education, and then distinguish me from that by saying, well, I don't have that combination. I think
I'm not sure that I agree with you, Mr. Mitchell, because, I mean, one way to look at this is it's completely irrational for the Commonwealth or any other state to, in essence, look at the experience practicing as an attorney, so that, you know, some people may argue 5 years or 7 years is too little, it should be 12, whatever it is, but you just can't do that. You've got to stick to your guns and have everybody, no matter what their experience, go through exactly the same requirements of somebody who has never practiced law. And it strikes me that it's not a bad idea to have people who have had practice, you know, who have practiced as an attorney, and we can look at that and the Board makes a determination. But you're asking us to sort of back all of that out and to say if somebody has no experience, none whatsoever, we should admit them.
Well, what I'm suggesting is not that you should admit them, but that you should permit them to demonstrate their competence. Let's look at these attorneys. These are people who have gone to law school. They have gotten a Juris Doctor degree that is accepted by the state in which they became admitted.
Is that by statute or by court law?
In California, it is by a statute. It's
the same that we have in Massachusetts for non-ABA, for some non-ABA.
Well, California has a very kind of a complex combination. They have different categories of schools, but ultimately, I think this Court's requirement is that it's not sufficient that one be a member of another state's bar. One has to have a Juris Doctorate. In my case, I have a Juris Doctorate from a school that is authorized in California to grant these degrees. Now, these attorneys or these applicants who have their Juris Doctorate then go on to satisfy all the requirements for admission in a sister state, including passing that state's bar exam, the ethical investigation, and so forth, and then are admitted to that state's bar exam. Now, my suggestion to you is that there is no rational reason why such an attorney should not be able to come into Massachusetts and simply demonstrate that the attorney has the skill, the knowledge to practice law in Massachusetts by passing the objective.
Is it part of your argument, perhaps in the equal protection area, that Massachusetts attorneys who are similarly situated, or Massachusetts law school graduates, by reason of the statute that was just referred to, namely those who graduate from, I think we have 2 unaccredited schools, who are permitted to take and pass the Massachusetts bar, whereas someone like you who's out of state and passes the sister state bar cannot be admitted here by reason of the Board of Bar Examiners' rules, that creates an equal protection problem between our citizens and
that creates precisely the equal protection problem that Corliss was arguing at the time, back in 1997.
Would it also create a privileges and immunities problem? Have you thought of that?
I have thought of it, and at least at the federal level, those have been uniformly rejected by the courts.
Okay.
I would suggest that were you to, in light of my argument, be sufficiently convinced that you decided to back off and make it more stringent, that perhaps could raise a privileges and immunities question.
Mr. Mitchell, here's what I'm looking at is this. And the reason why I asked you the statutory question, legislatures may pass statutes for a variety of reasons. A court, and I think it's in all 50 states, it is the court of last resort that decides qualifications, says you need ABA, you need a JD. I'm talking about initial, not foreign lawyers or people who've practiced. You need to be admitted by an ABA accredited institution, and you need to pass, the bar exam, in essence. Massachusetts, for whatever reason, the legislature, not the court, has said there are 2 law schools here, and graduates from that law school must be permitted to take, to sit for the bar. Right?
I was unable to find such a statute. I find it in the Supreme Court rules, in Section 3.3 of the Supreme Court rules.
Section 36.
It very well could be. I would suggest, though, that based on opinion of the justices 1935, you are not bound by that
No, but I'm
statute.
trying to look at it from California's point of view. So somebody goes to California, graduates from a non-ABA accredited Massachusetts law school, is admitted in Massachusetts, but California doesn't say everybody who's admitted in Massachusetts automatically is admitted in California, and they look at this and they say, well, we just don't agree with that, whether it's by court rule or by statute. We don't agree with that. We're going to ask for.
Well, I think I see what you're getting at, Chief Justice Marshall, and I'm not suggesting that you need to allow graduates of unaccredited law schools become a member of a bar. But what I'm suggesting is that when in 1997 you changed the rule to permit graduates of unaccredited law schools from sister states to come in, at that point that introduced a constitutional infirmity, which I believe Section 3.3, modifying it to allow such attorneys to pass the bar, that will remedy that. What's the constitutional infirmity? It's the fact that you're saying, well, in order for a person to come into the bar, they have to have an appropriate legal education. These attorneys have an appropriate legal education.
But
now they have experience, and the experience of 5 years allows us to will waive the bar exam. They don't even need to demonstrate that they know anything about Massachusetts law. How is it then rational to say that a similar attorney who is willing to demonstrate his or her knowledge of Massachusetts law should not be permitted to be subjected to the objective evaluation that the bar examination provides?
I would have two questions come to mind. First, essentially what you're saying is because the Massachusetts bar examination does test knowledge of Massachusetts law, so as long as you can show that you can pass that bar exam, it doesn't matter whatever, no other qualifications are necessary, not law school or any legal training, because you've demonstrated knowledge of Massachusetts law. That's one response. And the second is, I think the rule is clear that experience actually counts. And it counts particularly in sister states in the United States with which we have some confidence as to the judicial systems that are operating in those states. And so it's not just knowledge of the law, it's knowledge plus experience.
Well, I would submit to you that it's knowledge, experience, and education as well.
Certainly.
But you're making the argument that wasn't reached in Corliss, because Corliss was just trying to take the limited exam, and you're in the position of saying,
I'll take the whole thing.
right.
Right. But I'm different from Corliss, and I don't press the claim in precisely the way that Corliss pressed it, because Corliss was trying to say that a graduate attorney who had, or an out-of-state attorney who had an education that was not recognized for any purpose in Massachusetts should be entitled to take the bar exam because graduates of unaccredited law schools are entitled to take the bar exam. So he had a higher burden, I believe, than I do, because you are already placing confidence in other states to vet these candidates for you in advance.
We're placing confidence in the ABA for the present time, right? And we're placing confidence in if you practice as an attorney in another state, and obviously if you're not disciplined and so on and so forth, and if you can show that you were practicing, you didn't take whatever, you weren't admitted to the bar and then you went off being a doctor.
Well, I would also then, at this point, want to bring up the foreign attorneys, because I think that addresses this question. Foreign attorneys who have an education that is deemed by the Board of Bar Examiners to satisfy the requirement, they are permitted to come in on motion if they have the 5 years experience that Your Honor is referring to, but they're also permitted to demonstrate their fitness by taking the bar examination. So there's an equal protection violation there that I think answers that. Now, Mr. Guberman, I'm sure, will respond, oh, but this is different. There's a rational basis for a difference here because we evaluate the education of these candidates individually. Well, frankly, I think that we can place more confidence in the state of California, the state of Wisconsin, just as they place confidence in this court and the Commonwealth that graduates of Massachusetts School of Law or Southern New England School of Law who are then admitted to the bar, that these candidates are competent. That's a pretty good vetting, if you will, of the candidates. That I think, you know, what can the Board of Bar Examiners really know about these foreign schools?
You mentioned, I think Mr. Guberman would say, because it's in his brief, that in one of the arguments is, well, the ABA doesn't evaluate any foreign law schools, whereas it does evaluate domestic law schools, and Massachusetts depends on the ABA accreditation. And what I wanted to ask you was whether you know, do you make any argument that it's not just that you went to to sort of put distance learning, like Concord Law School, in a different category than every unaccredited law school, because I take it by virtue of the ABA standards, at the threshold, Concord Law School could never get accredited because it doesn't meet the fixed facility requirements. So it's in a somewhat different category than Mass School of Law or a comparable school in Wisconsin that has a fixed facility but isn't accredited.
Yes, Your Honor. I make that argument in the third portion of my brief where I ask that if this Court does not agree with me regarding amending Rule 3.3, either for the equal protection reasons that we've been discussing or for the public policy reasons, that it consider, in light of the rapid evolution taking place now in the delivery of legal education, and in light of my specific qualifications, that it make just that analysis of Concord as if it were a foreign law school, and I cite Tachi.
Sure. Mr. Mitchell, do you happen to know, I mean, Concord is, you know, I mean, I think if not the first, it's certainly, you know, got a very distinguished faculty. Do you happen to know how many online courses, how many online law schools grant JDs in the United States?
I can't answer that reliably, Your Honor. It would be a very small number. If,
is it more than one?
Law schools that consider themselves to be online law schools would be
totally online, so they don't have
totally
any
online.
Yeah.
Would be more than one. That's my understanding, and that's why Concord refers to itself as the nation's first completely online law school.
There must be a competitor somewhere, right?
Thank you very much.
Thank you, Mr. Mitchell. Mr. Guberman?
May it please the Court, Assistant Attorney General David A. Guberman for the Board of Bar Examiners. The nub of the petitioner's argument, as I understand it, on equal protection, is that the graduation from any law school exhausts the legal education requirement for admission on motion. And respectfully, we disagree. You said in Osakwe that the basis of this Court's legal education requirement is intellectual and professional acculturation. Professional acculturation, at least in the context of an applicant who has not graduated from an accredited law school, refers to...
What if we look at, I agree with you in the general sense, but what if we look at his record at that law school and that law school itself? As I recall, at that law school, at least there's an abundant amount of information in the record, appears to have full academic requirements, a very distinguished faculty, including professors from some of the most eminent law schools in the country, stringent standards in terms of grades, exams, and all the other kind of stuff. And he succeeded on all of this. Is it possible to say, well, look, we'll look at these cases individually, and if the person has this kind of record and this law school appears to have and does have this kind of status, and you add the passage in the California bar, which is not an easy bar, that may be that may form the basis for some reasonable exemption to the policy that he's talking, or the rule that he's discussing with us today?
I would suggest, Your Honor, that if further explored, what's the substance of the courses that were actually taken, who were the professors, what was the nature of the interaction between the students and the professors, how much does that resemble or differ from the interaction between the same professors in, we'll call them their home law schools, and students there, that possibly one could arrive at that conclusion. But that is a task that can't be carried on this record, and I would submit it would be impossible to draw a rational distinction between doing it in this one case and doing it in the case of every other graduate of every other unaccredited law school.
Do you think there's a hint here of the ABA engaging in a monopolistic practice?
That hasn't been claimed, and I don't think, Your Honor, that there is. I would call the Court's attention. I think that this is something that you may take notice of, that on or about August 15th, the American Bar Association section on law and education sent a letter to Chief Justice Marshall, along with all of the Chief Justices of the state Supreme Courts, notifying you that they are embarking on a comprehensive review of the standards for accrediting law schools. Now,
I understand that, and they've been doing that on a regular basis.
Yes.
It strikes me that, in a sense, your quotation goes to the nub of it. Heretofore, the ABA's position has been that there is something special, different, unique in face-to-face teaching. I mean, in addition to the how many, what your physical facilities have to be in terms of libraries and student-staff ratio and so on and so forth, that there is something inherent in, whether you want to call it the Socratic method, whatever you want to call it, there's something important about that. And so heretofore, the ABA has taken the position that online law schools don't qualify. Correct? I mean,
Yes, Your Honor.
they could go and evaluate, I think the case we had was from Nigeria, they could go and evaluate those schools, but they don't for resource reasons, but they do Canadian law schools. But that's their explanation, not that they don't have the time or the expertise. They have a position, right? At the urging of the Conference of Chief Justices and at just about every state, including this court, we have asked the ABA to take a look at online accreditation.
Yes.
But in the meantime, we have a petitioner who says you can do that in the sense of deciding whether that piece of why the ABA does not accredit remains valid. That doesn't mean to say that we open it up for all online, but that's the nub of the matter here. That's the nub of the matter here.
Well, it is part of the heart of the matter, and I would suggest that the Rules Committee and the working group that you set up considered these questions, and that if you're going to consider granting a waiver either individually for the petitioner or categorically for graduates of Concord Law School, that the appropriate way of getting to a decision on that is precisely that method, appointing a working group, considering some of the questions that I tried to mention earlier, and arrive at a considered policy judgment about what you want to do. I believe Justice Brandeis has said that it's one of the happy incidents of our federal system that individual courageous states may choose to act as experimental laboratories, and Massachusetts could decide to be an experimental laboratory with regard to graduates of online law schools. But I would suggest that in deciding whether or not to undertake the experiment, the court ought to give serious consideration to facts that are not before it on the record of this case.
But isn't that precisely the individual inquiry that needs to be made in these cases? Why is his situation any different than a foreign student, a foreign graduate, a member of a bar of some foreign country? The BBE makes an individualized inquiry as to the type of education that person received, and in some cases recommends that the person take additional courses. Why can't that all be done in his case?
Well, in most cases, it perhaps could be done in his case. The problem is...
I think the answer to that, in Pat, and I don't mean to answer Justice Spina, but I'm trying to think of what the ABA says, is that I don't know that we have a candidate from a foreign country that has taken online courses in the foreign country. It is because the ABA, to whom we look for guidance in large part and substantial part, has said so far, we just don't agree that online legal education, even taught by the best legal minds to the smartest legal students, is the functional equivalent of in-classroom learning both from teachers and from other students.
Except that with the case of foreign law schools, we don't know that in every instance they teach by the Socratic method. We don't know whether it isn't a lecture format in which no questions are asked between professor and student.
No, I understand that. I mean, I'm not suggesting that. I'm just I'm just saying what the distinction is heretofore.
Yes, but in trying to answer Justice Spina's question, I want to go beyond, important as it is, the considered judgment of the ABA section on law and education. And I think that what I can say beyond that is, on the one hand, that the number of applicants from foreign law schools, according to the record, has been fairly manageable. And the board, even so, generally requires that they take additional courses in the fundamentals of American law. On the other hand, the number of unaccredited law schools.
But there's lots of limitations to that. I mean, that Mr. Mitchell represents. You've got, yes, it's an unaccredited law school, but it's an online law school. He is a member of the California Bar. California, by statute, allows him from that law school to be a member of the bar. He's admitted to a variety of jurisdictions. I mean, there are. I don't think that there's a legitimate, or there needs to be a floodgates argument here that has to obtain, I guess is what I'm saying.
Well, with respect, Your Honor, there are a large number of people who graduate from unaccredited law schools in California and take the California bar, and we don't know what the implications would be. But leaving aside the question of the limited resources of the board, the system that California has chosen to control the quality and admissions to the California bar is a different system than the one that most other states, and specifically than Massachusetts, has chosen. As the Minnesota Supreme Court said in application of Hansen, a case that for other purposes you've cited with approval, California relies principally on its bar examination. Other states...
And it has a pass rate that is significantly lower than Massachusetts.
It has a lower pass rate, though, according to the data in the appendix, graduates of accredited law schools, such as Stanford or Harvard or Yale, have pass rates that are higher than the general accredited pass rate in Massachusetts. So I wouldn't want to overestimate.
Do we know what the pass rate is among bar exam takers in California who have graduated from Concord?
In the record.
It's in the record, Your Honor. I don't recall what it is. So I think it's on the order of 40% or 38%, but I don't specifically recall.
But your fear that they're all going to migrate up here and try to sit for the Massachusetts bar is really unfounded. Most of them are going to stay in California or nearby.
We don't even know if they're resident in California.
It's an online law school. They don't have, with the petitioner.
Well, that's true. Or they may, they're probably staying wherever their home state is, and perhaps very few of them would want to come to Massachusetts and sit for the Massachusetts bar. It only happened with him because he lives here.
Well, we don't know how, and this is a good question for a working group to consider if you want to explore the question, how many people who are residents of Massachusetts or a neighboring state would, if this route suddenly were made available, would take advantage of it.
Who do you put on this working group? The deans are going to say, well, look, we don't want any part of this. This is threatening our existence. And we do have requirements, most of them will say, where we take, so many credits of online learning and say it's okay at our school.
Well, I don't want to second guess your judgment and who you would put on the working group, but I would suggest that it is unlikely that the deans would feel that their institutions were threatened by an online law school, or at any rate, I'm sure that the court could find deans whose schools would not be threatened.
But Mr. Guverman, on your argument about how we use a different system, but isn't one of Mr. Mitchell's points, yes, but, I mean, we do allow people to take the bar exam from 2 unaccredited law schools, so...
Well, the answer that I would give you, Your Honor, is that those law schools are subject to the supervision of the Board of Higher Education. I guess it's now the Department of Higher Education. And I would analogize that to the case from the Nevada Supreme Court where they said, we will allow a graduate of this unaccredited Nevada law school to take the bar examination based on, 1, an extensive record, and 2, our personal knowledge of the law school. And I would suggest that the Board of Higher Education plays that role at any rate.
Isn't Concord, if my memory is right, approved or whatever you want to call it by some charter of the California Department of Higher Education?
Indeed it is, but it has never been your position that you have to give full faith and credit to admission to the bars of other states, much less, I would suggest.
Oh, no, I'm not suggesting we do that, but I'm saying the more you add all of this up and you take a look at it and you say, geez, this is the real deal here. This is not some fly-by-night thing where you know, for $50 you can get a PhD on the internet.
It's not fly-by-night. As I see that my time is expiring, I'd like to say a few words about the college education requirement, because you don't have to reach any of these constitutional questions. The problem with the petitioner's bachelor's degree is not the nature of the credits. That is, that some of them were from taking a college board administered test and some of them were double counted also to the Juris Doctor degree. The problem is far too few credits. If you look at the transcript, which is on page 75 of the record, he had, at the time he got his bachelor's degree from Concord, 48 credits from Concord. If you give him credit for 8 credits for each of the 3 courses that he took the exams in, that's 24 credits. That's a total of 72 credits. Colleges and universities in this country require far more than that. The University of Massachusetts in Amherst, I think may take notice of, it's available at their website, requires a minimum of 120 credits. So for that independent reason, you need not reach the issue with regard to his law school credentials, because he doesn't have an adequate college education, which is an independent requirement of this Court.
Thank you, Mr. Goodman.
Thank you, Your Honors.